Okay, Mr. Leonard.
May it please the court. My name is Brian Leonard, and along with attorney Andrew Dunlap, we represent the appellant in this matter, Mr. Saifuddin Alusi. The district court's order granting Frisco's motion for summary judgment should be reversed for several reasons. First, the district court failed to apply the totality of circumstances test in determining whether there was a fact issue in Mr. Alusi's discrimination claim for hostile work environment. Also, the court failed to consider the totality of circumstances test in Mr. Alusi's claim for discrimination based on national origin. Secondly, the district court applied the wrong standard of review on summary judgment when it resolved doubts in favor of the moving party rather than resolving them in favor of the non-moving party, in this case, the appellant, Mr. Alusi. In addition, the district court failed to draw all reasonable inferences from the evidence in favor of the non-moving party, as well as failed to consider the evidence in the light most favorable to Mr. Alusi as the non-moving party. Instead, the district court considered the evidence in the light most favorable to the moving party, which is not the standard on summary judgment. Third, the district court failed to consider proper evidence of comparators on Mr. Alusi's Title VII discrimination claim. In addition, the district court failed to consider evidence of pretext on Mr. Alusi's discrimination claim when he claimed that his termination was based on discrimination based on disparate treatment. In addition, the district court held that Mr. Alusi had to raise the issue of his national origin in order to proceed on his retaliation claim. However, the precedent of this court has held that the context of the discrimination can provide an inference for the court to find that there is a genuine issue of fact related to Mr. Alusi's national origin discrimination claim, such that he didn't have to raise it, but it could be inferred from the circumstances of the discrimination. I will address each one of these in turn. First, whether there was a reasonable jury could find Mr. Alusi suffered discrimination based on his national origin. This court has held in EEOC versus WC&M Enterprises that harassment is still actionable even if it is based on a nationality different from that of the plaintiff, as what has happened here. So the district court applied the wrong legal standard when it held that Mr. Alusi could not proceed on evidence of his national origin because it was not directed at Mr. Alusi's actual nationality, which is an Iraqi national.
Well, where's the, I looked at that case. I mean, sure, you're harassing somebody because you think they're I don't know, Iranian, but it turns out they're Iraqi.
Correct.
So I get that. But in this case, I thought the district court said the evidence you point to is not about national origin at all. It's about something else, another category of discrimination. So what's your response to that?
Well, my response to that is that in addition to the WC&M Enterprises case, it talks about the fact that you can infer from the other comments, just like in that case, like I said, I think he was of Indian descent, and they said that, I think they called him Arab, and then they also referenced Muslims. Also in this case, there's evidence that there's testimony that Mr. Alusi suffered comments that all Muslims are terrorists, and also that Mr. Alusi—
I mean, that sounds like religious discrimination, right?
Right, but right, and it appears from WC&M that the court said that it was possible that the court to infer that the discrimination was based on his religion or his national origin in that case.
Okay.
Thank you, Your Honor.
Thank you.
In addition, the district court failed to apply the totality of circumstances test in determining whether Mr. Alusi suffered discrimination based on national origin. And of course, the Supreme Court held in Harris v. Forklift Systems that you have to apply the totality of circumstances test on a Title VII discrimination claim. you can't just look at a single factor, but you must look at the totality of circumstances. And we would contend that the district court failed to do so.
What were those circumstances?
Well,
What should have looked at in making that determination about national origin harassment?
Yes, Your Honor. There were several instances. There were comments about using the word yellow, and there's evidence that Mr. Alusi never had spoken Iraqi to this individual. There were comments about all Muslims as terrorists in the record. There were issues where Mr. Alusi was forced to do menial tasks that other firefighters were not forced to do. And in addition, Mr. Alusi had also indicated prior to being transferred that he felt like he was subject to a hostile work environment. And so we're saying if you add all of those comments, you add the menial tasks, in addition, if you add the actual subject of his termination, which is essentially a business dispute, okay, an off-duty conduct for which there's evidence that other employees in the city engaged in a side business without registering with the city. If you add all of those things together, plus finally the testimony of the chief pilot, who was the ultimate decision maker, that there were these other reasons that Mr. Alusi that he relied on in terminating Mr. Alusi, but those other reasons weren't indicated. And we would contend that if you add all of that, that's possibly pretextual, plus the other evidence was comments, that those are the totality of circumstances that the court should have looked at. We contend that instead the court isolated each one of these incidents rather than looking at the overall total discrimination.
I guess on that point, I mean, Mr. Alusi raises a number of different claims, but which one of the claims would it be relevant for us to say, because I've seen this in many different employment cases where, okay, let's assume that there was a prima facie case made of national origin discrimination, yet the employer had a legitimate reason to dismiss him because of this conflict about the side business and whether he was really telling the truth about him being disabled. Oh no, there was a video that showed him lifting a dog or something like that. How does that come into it?
So in terms of the legitimate issue, we would contend that there is an issue of fact on that. Because as we said, there's evidence that there are other employees that engaged in this side.
Well, but what about the, that would go to pretext,
Okay.
I think. But about where's the issue of fact with respect to the dispute about him not being able, needing a wheelchair, needing assistance?
Well, that part, one of the things that we would say is that, that's where we feel the district court only looked at sort of this idea of supersizing his time and things like that, instead of looking at the fact that no other employee was surveilled like that on workers' compensation. Mr. Alusi was not charged with theft or anything of his time. And so therefore, we would argue that that would not be a legitimate basis for termination because there were other firefighters that engaged in more serious conduct that were not terminated.
But is there a fact issue in the record with respect to him misrepresenting his health status?
Well, absolutely.
Where would I find that?
So that would be in his response to the interrogatories. I believe that's on tab 8.
Mm-hmm. Well, I mean, you don't have to. Well, I can look at it in the record, but just tell me what is the evidence?
Well, essentially, he contend that he did not. That he when he was injured, he had a clear injury. Mm-hmm. He was not, supersizing time. I mean, what he did off duty was not in conflict with the workers' compensation policy that the city had. And there is testimony by one of the deposition witnesses that, routinely in workers, that essentially the workers' compensation policy is really very fluid. It's not applied consistently.
Okay, so if moving from that then to pretext, your pretext argument is that there were other employees who also engaged in misconduct who were not disciplined in the same way.
Yes, Your Honor.
And that's the one that engaged in some sort of sexual activity, and there was one that was found with a beer.
Yes, and that he admitted to drinking while
okay. And those people what happened to those folks?
They were only suspended.
They were suspended.
They were not terminated.
Okay.
And our contention is there's precedent in this circuit that says instead of looking at sort of the different infraction in terms of comparators, that you should instead look at the seriousness of the offense. And we would argue in this deposition testimony that engaging in this sexual act on property, on city and fire department property, and engaging in drinking while in a city in a vehicle, and I think it had the fire department sticker on it, that those are way more serious than engaging in a side business or a business dispute that's off duty.
Well, and I may have misunderstood what I read, but I thought it wasn't just the side business. It was some of his conduct and behavior in connection with how he operated the side business.
Yes, Your Honor.
It wasn't just the fact that he had a side business.
Yes, Your Honor. That's their purported proffered reason, but we contend that that's pretextual because in the case of they say it's conduct, there's evidence in the record from Chief Powell's deposition testimony that he tried to represent himself or use his position as a firefighter for the city of Frisco to gain an advantage. But then the Sergeant Putnam's report, actually the report that the city that Chief Powell relied on, to dismiss Mr. Alusi, that was not sustained. Sergeant Putnam actually indicated that he did not find that Alusi attempted to use his position as a firefighter.
So the conduct unbecoming a firefighter.
Correct. And that's what we're saying. What the termination notice is that it's conduct that brings a bad light on the city. So we would contend that conduct bringing a bad light to the city, that engaging in this sexual activity on city property, engaging in drinking while in a vehicle with the fire department sticker would bring a bad light to the city as well. However, those two employees who were under the same decision maker, in this case Chief Powell, were not terminated. They were only suspended. Only Mr. Alusi was terminated for we would argue, less serious conduct. Thank you, Your Honor. In addition, a reasonable jury could find that Mr. Alusi was subject to an indicia of prejudice under this court's holding in Byrd versus Roadway Express Transportation, that all of the comments and all of the actions with respect to Mr. Alusi would create an indicia of prejudice such that a reasonable jury could find that he was subject to discrimination. In addition, whether or not the city of Frisco took prompt remedial action, we would argue that initially Mr. Alusi made his initial complaint of a hostile work environment, and that it was over almost 2 years before the city actually investigated the discrimination. And this was after Mr. Alusi had already been terminated. So we would argue that's not a prompt remedial action to stop the harassment. Then we would argue that the district court failed to consider that a reasonable jury could conclude that Frisco subjected Mr. Alusi to disparate treatment when he was terminated. We would say the holdings of this court provides that comparator evidence is not required as part of the prima facie case. But even if it was required, we would argue that there are sufficient comparators that have been identified in this case that are nearly identical enough under the holding of this circuit to satisfy the element of having sufficient comparators. In addition, as we said, the district court failed to consider the issues in the light most favorable to Mr. Alusi and failed to consider proper evidence of pretext. In St. Mary's Honor Center versus Hicks, the Supreme Court, and in Turner versus Kansas City, in this court held that, again, prima facie case is not onerous, essentially showing that you were treated less favorable than other employees outside of the protected class is sufficient. And we would argue that the district court, in holding otherwise, should be reversed. In addition, we say that the comparators are nearly identical enough. They all are firefighters. They all ultimately reported Chief Powell, the same decision maker, but the comparators were given more harsher punishment and Mr. Alusi was not. In addition, on the retaliation claim, we would say that the district court failed to consider proper evidence of pretext to support his claim of retaliation. And again, we would say that the court's order should be reversed.
All right, thank you, Mr. Leonard. You've saved time for rebuttal.
Yes, Your Honor. Thank you.
Curley?
Good morning. May it please the court. Kevin Curley for the City of Frisco. In May of 2020, the Frisco Fire Department, like departments all across this country, was dealing with the takeoff of the COVID-19 pandemic. And at that time, the Frisco Fire Department was down approximately 40 of its firefighters. It was in desperate need of first responders. In fact, it was even considering restructuring its shift command structure in order just to provide the city with the protection it needed. With that background, this case presents the question of why the former fire chief, Mark Pylan, who was the same actor that hired Mr. Alusi, having knowledge of what his national origin was approximately 2 years before that, would have chosen to terminate employment. And I submit to you that the record in this case establishes that, as cited in the brief, as cited in the investigation that was conducted. That investigation found numerous violations that pertain to misrepresentation, dishonesty, and integrity type issues, which led to the termination. Before I get into responding to the retaliation, the disparate treatment, and the hostile work environment claims, I want to run through some basic background information that led to what we are dealing with. And if we jump back about 7 to 8 months before Chief Pylan terminated Mr. Alusi, what we know is that in July of 2019, Mr. Alusi had transferred to a different station, Station 6. Mr. Alusi reached out to the battalion chief, Jeff Morrison, asked if he could meet with him to address a, quote, hostile work environment. Mr. Alusi readily admits that at no time did he connect anything that was being done to him to his national origin of any kind. What he did allege was that he didn't think Station 6 was a good fit. The crew had not acknowledged him when they saw him at a grocery store, and that while they were doing training exercises, he was forced to do some additional training. That was generally the extent of what his complaint of the hostile work environment was. Battalion Chief Morrison asked, "What would you like to have done?" At Mr. Alusi's request, Mr. Alusi said, "I want to stay under you, Chief, and what about Station 7? Mr. Alusi was transferred there at his request. When I asked Mr. Alusi in his deposition, could you have identified a better station to be transferred to, his answer was, no, he could not. He went to Station 7, jumped to February of 2020, right before the COVID pandemic started, and at that point, Mr. Alusi was injured in a training exercise. As a result of that injury, he submitted and went on a workers' compensation claim. While he was on his workers' compensation leave, the record shows that there were ever-changing dates of when he could return and what his limitations may be. In early March, those culminated with Mr. Alusi representing to the department that he needed a wheelchair or a walker to be able to come back and do any work in any capacity at the fire department. The fire chief said, okay, we'll accommodate that. In that time frame, there were three things that occurred, one of which was the court had already referenced that there was an investigation on conduct of the business. In fact, what that was two independent, unsolicited complaints that came to the Frisco Fire Department regarding business activities that Mr. Alusi was engaged in down in Central Texas. And in that same time frame, one of the fire chiefs at the Frisco Fire Department observed Mr. Alusi walking around the Home Depot, having seen the representations that he needed a wheelchair or a walker in order to do any job back at the station. And thirdly, as the court has referenced, there is a video of Mr. Alusi the day before he was to require a wheelchair and a walker, picking up a large dog and hoisting it into a Frisco Animal Services vehicle. Certainly not using a walker or a wheelchair and showing capabilities well beyond what had been represented to the fire department and the chief. Chief asked for an investigation. That's where this surveillance issue went in. It was confirmed that the representations as referenced were not consistent with what was actually going on for Mr. Alusi. In his deposition, Mr. Alusi acknowledged he may have been lifting furniture and doing other work out at the property where he was doing work at that time. A full investigation from Sergeant Putman commenced. That is consistent with the Sergeant Putman and the Professional Standards Unit of the Frisco Police Department did all of the internal affairs investigations for the fire department. So that was standard, that was normal for him to look into the allegations. Ultimately, based on the investigation findings, I think there were 16 pages or so that included misrepresentations, untruthfulness, acting in an unprofessional manner, threatening third parties, insubordination. Chief Pylon terminated Mr. Alusi. Now, while the performance deficiencies in Mr. Alusi's overall performance, which is certainly shown in the record, was not a specific reason that Chief Pylon terminated, what Chief Pylon did acknowledge is the, quote, other reasons, the things he considered in conjunction with the investigation, was the overall employment picture. That led to the termination. Mr. Alusi appealed that termination. And in the first level appeal, there was no allegation of national origin harassment, national origin discrimination. In fact, the record cites to Mr. Alusi's own letter, while he was represented by counsel, that he was appealing because he was, quote, solely being retaliated against for taking a workers' compensation claim. Jump to the second phase of his employment appeal. In that phase, which was before the city manager, Mr. Alusi retained a new counsel, and for the first time ever, raised the issue of his national origin playing a role in his termination and claiming that he sustained harassment during his employment based on national origin. The city of Frisco hit timeout, brought in an investigator from the Human Resources Department that did a thorough investigation. Ms. Ross, herself a black female over 40, conducted that investigation. That's in the record with her findings, and ultimately the termination was affirmed. To the legal issues presented in the three...
With respect to national origin discrimination, what did the findings address that?
Yes.
The allegation?
Yes, and it thoroughly goes through most of the allegations. I think there were a dozen employees that were interviewed, and there were no findings that sustained any national origin discrimination. Frankly, there were no findings that addressed any type of harassment or discrimination, but certainly none that pertained to the national
Of the
origin.
comments that I've heard discussed so far, the ones that I think were focused on was the referring to him by using an Arabic phrase, and also the comment about Muslims and terrorism. Are there any other comments that you're aware of that would even arguably go to national origin discrimination?
Not that I'm aware of, and certainly I don't believe that the briefs from appellant have indicated that there were.
One refrain from the other side was that the district court failed to look at the totality of the circumstances. That seemed to be a separate point. What is your, if you have a sort of a general response to that?
Yeah, I'll jump ahead to that. So the totality of the circumstances standard is part of the hostile work environment claim. And what I think that appellant is doing is conflating the third and the fourth elements of that analysis. And so I think there are two responses. The first is I think that the case law says that Judge Jordan at the district court was supposed to go through the various separate allegations and determine whether they constituted any type of harassment based on national origin. Address those separately. There's the Hernandez versus Yellow Transportation case. There is the Price versus Valvoline case. There are several cases that are cited in the brief on this issue, and what it requires is that only those elements of harassment that have been identified and evidence has connected to being for the protected class are considered in the totality of the circumstances. That's an element 4, and Judge Jordan did that. What Judge Jordan did was in element 3, walked through the various allegations to acknowledge whether there was any evidence connecting those to national origin. So I think that Judge Jordan actually may have done the plaintiff a favor because he walked through everything and said, you're not connecting anything to national origin, but let's assume that you...
But did he say, at least in part, it's not connected to national origin because they misidentified national origin?
No, Your Honor, I don't believe there was any connection to misidentifying national origin like in the EEOC claim. I think what Judge Jordan's opinion said was that there were some references to color of skin and to Muslim, which would be religion, which were not, unlike the EEOC, WC, and M case. There, the plaintiff had brought both religion and national origin discrimination claims.
And in WC and M, they did misidentify national origin.
Yes, there what it was right on the heels of the September 11th attacks. What the co-workers were referencing to go back to his country and things of that, but they weren't specifying what country that was. And so the court in WC and M said that connection was not necessary. You didn't have to correctly refer to the specific national origin, but that's not what we were dealing with here. The two that plaintiff brought up in their opening argument was the Muslim, which
You're saying that's not one of the determinations that drove Judge Jordan to conclude that there was no national origin claim in this case. He didn't make any determination about misidentification of national origin.
Correct. And the reason I think he would have omitted doing so was because I don't think there was any allegation that this related to national origin of any kind, much less the Iraqi national origin that Mr. Alusi was basing his claims on. If I may jump back real quick on the retaliation claim. So the district court granted the city's motion to dismiss earlier in the case, dismissed Mr. Alusi's retaliation claim because Mr. Alusi failed to allege that he had reported any protected conduct to Battalion Chief Morrison when they met in September of 2019. The court specifically identified what Mr. Alusi needed to correct in his amendment. He did file an amendment, but he made no changes to that portion of the complaint. Arguably, it revived for summary judgment. I couldn't find any case law on that specific issue, but the fact of the matter is, still at the point that summary judgment was considered, they had not alleged protected conduct under Title VII. There certainly have been no evidence supported, and the best they can say is that, well, we used the phrase, quote, hostile work environment. Well, this court has addressed that very phrase and said that is insufficient until you tie that to your protected class. That's Davis versus Dallas ISD. There's also a couple of other cases that are cited in the brief on that issue. One is the Chaudhry versus BP North America. They're, quote, complaining about unfair treatment without specifying why the treatment is unfair is not a protected activity. In the Davis versus Dallas ISD case, it's directly on point with what we have here. The employee in that case complained of a, quote, hostile work environment without connecting that to any protected status, and this court said that was insufficient for the retaliation claim. Even if they had met their burden to establish a prima facie case on retaliation, I think the district court correctly noted there was no fact question on pretext of this substantial investigation with numerous findings or on causation. On the desperate treatment claim based on his termination, on the comparators, the brief discusses the two comparators and why I think the court correctly ignored those. I did point the court to the Lee case, which is kind of the seminal case on comparator analysis and the similarly or nearly identical standard that this court requires to be similarly situated. That case cites to the Bowie case, and there the comparator was alleged to have committed one safety protocol violation, whereas the plaintiff in that case had committed two. And this court said that if we're comparing 2 and 1, that is insufficient for the nearly identical standard. So to isolate any component of this thorough investigation and say, well, we might be able to find an employee that did one of those, that does not establish an inadequate comparator. The Dodge case, the general idea of dishonesty, this circuit rejected that as being a basis for a comparator. We have to get down in the weeds and have conduct that is nearly identical. Trotter, case, and Justice Smith, I believe you were a part of that decision, but in that case, the opinion distinguishes between fighting with coworkers not being the same as fighting with a supervisor. So the act of engaging in fighting alone would not bring someone into a comparator. The idea, in addition to the conduct at issue not being related for the two, there were certainly no findings or issue of dishonesty, untruthfulness, insubordination, any of those things with the other two comparators. Judge Jordan also noted that plaintiff failed to offer any evidence on what these comparators, what their positions were, their duties, their supervisors. The idea that they all, I heard in the opening argument, that, well, they all reported to Chief Pylan. Well, that was not sufficient in the West versus City of Houston case. There, they actually went through and they specifically said, it was a firefighter case alleging discrimination and harassment, and they said, you've got to go to the specific, what job do they do? Being a firefighter isn't enough to be a comparator. Having the same fire chief isn't enough. What's your specific duty and role? Are you a driver operator? Are you in suppression? What's your role and who is your supervisor? Chief Pylan alone is not enough to connect that. I heard argument that there was no requirement to have a comparator for a prima facie case. As recently as a few months ago in Clark versus City of Alexandria, this court reiterated that is a requirement. You show you were either replaced by someone outside of the protected class or you have a comparator analysis done. But even if they had the prima facie case, we're back to the issue of the legitimate and overwhelming reasons for termination. And I think the district court went through that pretty well. I hope that the court finds that the brief does as well. But the investigation found numerous different policy violations, numerous things that were connected to the department enough that two individuals felt compelled to reach out to the department to complain of what ended up being one of the complainants alleged that Mr. Alusi was, quote, a con man. So those were the types of allegations being brought back to the fire department. The other reasons or other factors, I touched on this briefly before, that's cited in the brief. Plaintiff's counsel didn't ask Chief Pylan what those other considerations were, but what Chief Pylan did elaborate on in his unsworn declaration was that what he considered was the overall employment picture that included a firefighter that had, at every turn, had deficiencies in his.
Mr. Curley, if I could go back to the hostile work environment claim. We were talking earlier about the WC&M case. This is the misidentifying the nation of origin. Let's assume with me that Judge Jordan was actually wrong about that and that the evidence in this case, the Muslim comment, the Arabic comment, those actually, we should infer that they're national origin discrimination. Does that mean, is there any other way for your client to prevail on that claim if that's true? And I'm not saying I agree with that, but let's just assume that.
Yeah, absolutely. And the reason is this. Judge Jordan, when he evaluated the totality of the circumstances, he expressly said, let's assume that all of these related to national origin. We still don't meet the standard that this court has set forth. And there's really three cases that I would point you to, and I pointed the court to in the brief. One is the West versus City of Houston case. The second is the Price versus Valvoline case. And the third is the Clark versus City of Alexandria case.
And what is the idea, though?
The idea of those are the facts were connected to the protected status. They were substantially more than what we have in this case. And in each one of those cases, the panel said it was not sufficient to meet the heightened standard for frequency, severity, and the other.
I see that these
pervasiveness,
yeah. Okay.
Severity or pervasiveness. And for example, I think in the West case, you had, my goodness, it was a gender hostile work environment case that had some pretty extreme conduct by some guys in the firehouse, to say it lightly. And the court went through and said, well, the plaintiff only showed that those occurred on one or two occasions. So once X harassing event occurring on one occasion or Y occurring on a couple of occasions, that is not sufficient for the pervasiveness, the frequency. And the court cited a couple, in West versus City of Houston, cited a couple of cases on what that standard is. Example, receiving 10 to 15 calls a night for 4 months. 2 to 3 times a week something is happening. What Judge Jordan correctly noted was, even if we think all of these are connected to national origin, these are one-offs, and that's exactly what we've dismissed in the 3 cases that I noted the court to. I think, jumping back to the element 3, and I'm bouncing a little bit based on questions, but element 3 of the hostile work environment claim, when Judge Jordan went through and said plaintiff hadn't connected any of these to his national origin, he also did plaintiff a greater favor. He then went through and analyzed what the city had offered as far as evidence on these various issues. For example, well, you turned off the valve on my tank. Well, the evidence submitted, including from the training director, was that is something that all of the firefighters go through. That's something that you learn how to deal with, your tank being turned off. Do you not just grab your mask and rip it off? Do you go through the protocols to maybe unkink your hose or things like that? So the court went through a lot of these allegations, even saying, well, you didn't connect them to national origin, but here are the legitimate reasons on that.
All right, your time has expired now, Mr. Curley. Thank you. Mr. Leonard for rebuttal.
Thank you. May it please the court. Just to address some of the issues raised by the appellee's counsel, one of the other issues that we cite is that Judge Jordan, and certainly much of the cases cited by the appellee's counsel, both in their brief and here at oral argument, including the Bowie case, the Dodge case, the Trotter case, all are unpublished opinions and unreported opinions, and therefore are not binding precedent on this court.
Well, they can be persuasive.
They can be persuasive, Your Honor, but not binding. And one of our contentions is that Judge Jordan, in his order, relied on some of these unpublished, non-binding precedent. In addition, we would argue that there is a dispute of fact, that much of what we've discussed here today establishes that there is a fact issue for the jury on the hostile work environment claim, on the whether there was pretext in the termination of Mr. Alusi. There are genuine issues of material fact in dispute. We would contend that the comments based on the comments to Mr. Alusi that the court, under this court's precedent, can infer discrimination based on those comments. In addition, there's evidence in the record that no other employee was surveilled while on workers' comp. No other employee was investigated by the police department on workers' comp. Mr. Alusi, there's no evidence in the record that he had committed a crime. And so our contention is that all of this shows disparate treatment toward Mr. Alusi, and also potentially pretext. In addition, speaking of persuasive authority, in a sister circuit, and we cite in our brief Andrews versus City of Philadelphia, a play cannot be understood on the basis of some of its scenes, but only on its entire performance. And similarly, a discrimination analysis must concentrate not on individual incidents, but on the overall scenario. And we contend that Judge Jordan in the district court, instead of looking at the overall scenario, they look at the isolated incidents. In addition, we would say there's a fact question in terms of the actual reason for Mr. Alusi's termination, because Appellee's counsel mentioned the other reasons that Chief Pollen did not indicate, and he also mentioned performance. However, there's evidence in the record that Mr. Alusi was not on a performance improvement plan. So we would argue that under the holdings of this court, particularly in the Burrell versus Dr. Pepper case, that shifting justifications for the actual termination could be evidence of pretext. And we would contend that the district court failed to see the shifting justifications. First, it was, dishonesty, and then it was supersizing workers' comp. Then it was sort of post hoc, the appellee and the employer mentions performance issues. Although, if there were truly performance issues, we would contend that Mr. Alusi would have been placed on a PIP. We think all of these things show that there are issues of fact here that is the province of the jury. We would contend that the district court engaged in weighing evidence and making credibility determinations, which is not the province of the district court. That is the province of the jury. Again, we would say that the district court's order did not rely on precedent that is binding in this circuit. In conclusion, there's binding precedent in this circuit based on the U.S. and the U.S. Supreme Court that clearly indicate the district court's order granting summary judgment should be reversed. The district court failed to apply the totality of circumstances test on Mr. Alusi's discrimination claim, as well as his hostile work environment claim. They applied the incorrect standard on summary judgment and not viewing the evidence in the light most favorable to Mr. Alusi as a non-moving party. And they also failed to consider evidence of comparators. And considering the comparators had to be completely identical rather than nearly identical. For all these reasons, we say that this court should reverse the district court's order based on the non-binding precedent and the binding precedent that require the district court's order to be reversed. Thank you. Thank you.
Thank you, Mr. Leonard. Your case is under submission. The court will be in brief recess before hearing the final two cases.